Once again, we are here on behalf of MR Solicitors with our Facebook live session. Today, I have with me our guest, as usual, Qazi Imran Iqbal Sahab. We supposed to have Nazir Naji Sahab today, but due to his ill health, he could not join us. So we have the famous Qazi Imran Iqbal Sahab.
Thank you, sir. Thanks.
Today we have a lot of questions already with us via email, and we will have obviously questions from you here as well. To start with, we have some updates here. So I would like to start with the updates. So we can I'm just trying to share with other pages as well. So the question is, before I think we go to questions, the updates are about the important updates are the service centers here in the UK, the biometrics service centers. Home Office has made an announcement that they have opened from 24th of September already. So the applications you have been making, you don't have to wait for their email or for that ID process they had started. So you can just book the appointment as you used to do when and where it is available. Most of the appointments available are not free of charge. They are the paid appointments, so as long as they have started at least. Apart from tier 4, the student visa. The student visa biometrics have not been started yet because they're still trying to devolve a system, and they may not have to go through that system. So you still need to wait for their emails, and most likely it will be still on the ID app. Those people who have already received emails that they can use the app, they can do so. They don't have to book the appointment. So it's only for those who have been waiting for the emails from the Home Office can go online and book their appointments. And any new applications, if you're making, again, as before, you can do so by going online. So apart from student visas extensions, you can do that. Apart from that, the other important information, as you may well know by now, that those people who have come to UK and their visa or leave was expired after 24th of January, the Home Office initially announced that they can just send us an email and they can stay here until 31st of May. Then that deadline was extended to 31st of August. So 31st of August was considered as the grace period. However, still there is a scope, and that particular deadline has been extended until 31st of October. The difference is now you have to satisfy the Home Office that you have exceptional circumstances, like you cannot get the flight to go back, or there are symptoms that you have some coronavirus symptoms, or there are exceptional circumstances so you can still stay here. Again, you just need to send them an email, and your leave will be extended. It's like a temporary stay. And if you stay here or overstay here, it will not be taken against you. It will be considered as valid leave. Still, if those people who are here on visitor visas and they still cannot go back for these reasons I have mentioned, they want to switch their category to any other visa, which normally they're supposed to do from their own country of origin, go back and make an application from there. Still, they can do that switching from here until end of next month, until 31st of October. So still there is a chance now to make applications. Imran sir, what do you say this, the further flexibility Home Office has extended this until 31st of October. What do you think? Still, I have come across that people still don't know, and they have become overstayers. They didn't know about it. So what do you think? There's a lack of information from Home Office. There's lack of information from our lawyers community. What's happening? Actually, or people are not interested in getting the information?
No, basically it's lack of information from Home Office. It's properly lack of information. they have not guided people properly, and the people are all also confused. Lawyers are also confused. Some lawyers, they are at the view that they should make a paid application, extension application with the reasoning and all that. But I got experience that when we send the extension email to the home office on the similar email, which obviously can be obtained from website, and telling them the compassionate reason. That's why one of our clients, he has same scenario. He has same scenario, and he has been refused entry to his native country due to the COVID and all that. And I sent the email to the home office, and they accepted his plea, and they said that temporarily they are extending his visa for another few days, which is obviously he saved his immigration status, and he saved his future prospect to come into the UK on a visit visa. But yes, there is a turmoil in the home office, and they don't know how to handle this situation properly. But I think would like to tell viewers this: please, whoever suffering these type of situation, they should contact the home office to make a paid application. It's not a good idea because fees are really high. It's just a simple email and mentioning them the reasoning. So I think that should be the idea.
Yes, so if you are listening to us, then please make note of it, that you or your friends or your family who are here on any kind of visa and they would like to switch their category to any other category, for example, student visa, parents dependent visa, children dependent visa, or any other visa where normally you have to go back and apply from abroad, you still can make an application whilst you are in the UK. You have to make an application using the UK application form and paying the UK application fee. The other question which is coming back again and again about this fee waiver application. So if you are in the situation where we call destitute, meaning that you cannot meet your ends, you are not earning or you are earning very less, you are not on benefits or you are having very less benefits, and you cannot afford the application fee, which is typical 2,053 pounds per application to home office. So still you can make fee waiver application. So if either you can engage your lawyer, which again you may have to pay a little fee to them, there is the home office fee for that, or you can do it yourself online by filling in the fee waiver application form, disclosing all the relevant information. So if people, if they have bank statements and their bank statements are showing that they have a lot of transaction in the bank, then it is very, very less likely that home office will accept your plea. However, if you don't have bank account, or the bank account is there, but there are no transactions, or there are transactions, but you are justifying them that your income is less than your expenses, then still home office will consider it compassionately, and very, very likely they will give you fee waiver, fee exemption, and then within 10 days you need to make the application, the particular application you want to make. The question is 7 years. Yes, the child policy, the 7-year child policy, it's still a valid law. There is no change. Some people thought that it has been changed to 5 years, that they are confusing this 5 years stateless child situation. For some countries, and I give particular example of India, that India does not allow dual nationality, first of all. Secondly, the child which is born outside India is not automatically an Indian national, unlike Pakistan. A child is born outside Pakistan as long as he has at least one surviving parents, Pakistani parents, or his link is with Pakistan, so he is automatically by birth Pakistani national. But in relation to India and many other countries, the child is not automatically Indian national unless you go and register them with Indian High Commission of the country, like in UK. So if you don't do that and the child is born here and the child has attained the age of 5 years old, he's still stateless. So by staying here as a stateless child for 5 years, he can directly apply for British nationality. So once he is British, his parents can make an application on that basis, and they will get the 2.5 years, 30 months visa under the 10 years category. So that is separate category. And the other category is any other category where the children are not stateless for these reasons, but they have spent at least 7 years in the country, and at the time of this make new application, they're still, or at least one of them is still under the age of 18. You can make an application and parents can again claim status on the basis of 7 years residing of their child or children in the UK. There shouldn't be any absence, but if the absence is during their visa. For an example, if a student has come here and he has 3 years visa, in those 3 years he has gone back to his country with his children and come back in time, that is not absence from UK if it's less than 6 months. So initially Home Office did refuse some cases on these bases, but when they were challenged, they accepted their mistake, and now they are not refusing on those bases. So you can do that. And initially when this policy came in 2012, initially they were only allowing single parents, and that was still challenged. And there's a famous case of PD and others, I believe, end of December, end of 2015, perhaps, if I'm right.
Yes.
Normally, I'm not right with dates, by the way. So if I'm right, but it's a PD and others, and following that, then both parents can make application on that basis, and they are getting status in the country. So yes, if your child has lived here for 7 years, then you can go ahead and make this application. So there is no change. Other announcement I wanted to make, that MR Solicitors has taken another initiative in immigration area, and that is for overseas students. If you would like to come to the UK as an overseas student, you can contact us, and for that particular area we have a new email address, which is admissions@m-rsolicitors.co.uk, or still you can send email on info@m-rsolicitors.co.uk. We have partnered with various universities, a range of universities in the UK, and we can arrange for you CAS within 24 to maximum 48 hours. There are universities which are accepting those people who have not done IELTS, few of them, but still there is availability, and most of them they still do require IELTS, English language test. So if you want to apply for that, please do send us email or your inquiry. We are getting hundreds of inquiries a week on student visa, because student visa, once you come here now on student visa, once you finish your degree or master degree, you will be able to get 2 years work visa, which used to be known as a post-study work visa. So you still can get that. Then the startup visa option is there, the innovator business visa option is there. Then obviously if you're lucky enough, you may be able to get the work permit, the Tier 2 visa, if you get the required sponsor. And the other change which is coming now in relation to points. So more powers are going to be given to the universities in terms of maintenance and all that. So there will be slight change, however, but procedurally, actually there will be not much, practically there will be not much change. Procedurally there will be change, but as I said, that students have these options available once they are here. Apart from that, startup visa is still there. If you want to apply for startup visa straight away from even overseas, you can. Innovator visa category is still there. The sole representative of an overseas business category is still there, and there are more categories coming for health visitors, as well as the highly skilled work permit kind of visa is expected to be announced sometime early next year or first quarter of next year. So these were the updates, and we'll go towards your questions as well now. If you would like to add, Imran, anything at
Yes,
this
sir.
stage?
One of the friends, he asked for the backlog of the cases which created due to the corona. Yes, there are so many cases which are still stuck from December and November. So gradually they are started resolving the cases. So whoever they have outstanding application in the Home Office, so please be patient. They are dealing with the COVID cases now, and they started working on them, and now we are getting responses. But obviously so many cases are over 6 months. Some cases are from last year, November and December. So I request everyone who are sending us inquiries about the backlog. So please be patient. Home Office started dealing with the cases, but please don't think so that it's a 6 month guideline, and they are not giving us responses within 6 months. So that's the update for the COVID related backlog. It's still there, and they are dealing with it.
Thank you. Another question is that I'm going for signing. I have a pending application in Home Office. Is there any chance they can detain me before the decisions on my application? Depending, I don't know what kind of application you have there. Detention can be done. They can detain anyone, but there are circumstances, just can't detain without any particular reason. So Generally speaking, if you have a pending application in the Home Office, it is very, very unlikely that they will detain you. Sometimes what happens, if it is a repeated application and the thing that you don't have any much chance in that, and you have been just submitting applications for no reason, just to buy time, sometimes you go there and they give you refusal in your hand, and they say, since there is no right of appeal, so we are detaining you and your flight will be in coming few days. However, if that happens, still you have an option of challenging that by way of judicial review, depending what kind of application that was. And if there is a merit, then definitely you can get the removal directions cancelled even. And we have cases in the past where clients were taken to the board, to the airplane, and they had come out of it. So generally speaking, no, they don't detain people if your application is pending. But again, if it depends on your personal circumstances, personal case. Yes.
Sir, another thing, if you would kindly elaborate this, some people, they have outstanding EEA applications in the Home Office, and they were under impression that their cases are still pending, but when they go, they detain them. And can you please elaborate this, whether EEA regulation, they are barred in immigration, or?
Yeah, there's a difference. Very good question. There's a difference between EEA regulation and UK immigration rules. So if your application is pending, whether it is EEA regulation or UK immigration rules, the procedure for detention is pretty much same. However, if your application is refused and you have gone on appeal against your decision under the UK immigration rules, normally they cannot remove you, they cannot issue removal actions. However, under the EA regulations, even if your appeal is pending, they can detain you and they can remove you. So that is a big difference. So people may not know that if their appeal is pending, yes, in normal circumstances, generally speaking, they don't detain you and they don't remove you because you do have a appeal pending, but legally they are not bound. They exercise this practice only when they know that you have been submitting applications and just getting appealed to by the time, or they think that it was a marriage of a convenience, sham marriage, or things like that. Then they do tend to remove you and they don't wait for the appeal. And sometimes even if you go for judicial review, it is not a good application. So the situation is different under European regulations and under immigration rules, no doubt. Thank you very much. It was an important question and people are falling into that. Another day we did have a case where they were under the impression the person was removed because he was married to a European citizen, and the Home Office did interview them and they refused it and they thought that it was a sham marriage. However, they were made to believe, the client was made to believe, not to worry, we will do judicial review, we'll get you out, and they would charge a heavy fee. But when actually he was actually removed, so when they came to us and we explained the correct situation, that this is the correct situation, so they could not believe that why they were not advised accordingly.
Yes.
So it is best to know basic information, and somehow some of the legal representatives do not know this difference. Okay, there's a question, and the interesting question is this, that in future, is there any possibility that the Home Office is going to reduce the fee? Well, actually, we believe that it's going to be opposite to that. There are rumors, and it may be true, that very soon they are going to increase IHS fee. The Immigration Health Surcharge fee may be increased. We are not sure, but it may be increased in coming future. But there is no suggestion that Home Office is going to reduce the fees. And in my 22 years of experience, I haven't come across that at all, that if they have increased, that they will decrease. Yeah, there were one or two instances where the court fee was for appeals were introduced or increased and they were taken back, those decisions. But in terms of Home Office fees, I don't think so there's any chance. Another typical question about, we get these questions many times in every session, and that is there going to be any announcement or amnesty for overstayers? Again, unfortunately, the answer is, as usual, we used to say before, there is no option at the moment. There is no suggestion at the moment, even though myself and other lawyers have been expecting this for some time, but it seems that at least until Brexit, there is not going to be anything like that. Even though the Prime Minister, when he wasn't Prime Minister, probably he made so many times announcement that people who are here for 10 years or over, we will consider them and we will give them stay. But the Home Secretary Priti Patel categorically withdrew that statement. So we don't know if there is going to be any or not, but people who are here over 15 years, less than 20 years, still should be making application. But please do consider your personal circumstances, your family circumstances, your economic, social circumstances. And if you can, try to convince the Home Office that we have this education, we have this skill, we have this experience, we have this business plan, we have these resources, that we can create our own business, our own economic activity where we will be able to accommodate even unemployed people from UK. They may consider it favorably considering the present circumstances. So please do consider making application on those basis. But if you do not have any of those, then better not to make an application until you have spent, unfortunately, 20 years in the country. So it is always better to speak or get a professional advice on that, what circumstances should be considered and what circumstances the Home Office is going to give weight. There's enough case law on that. Another question is that last week in the news, Prime Minister addressed that they want to remove European human rights laws. Is it going to affect the 7-year child route? 7-year child route is not a European law. It is UK immigration rules under UK rules. It is a 276 paragraph, and it has become, the Article 8 has been included in UK law in that regard. Yes, they are not bound to follow the Human Rights Act, the ECHR, European Convention on Human Rights. However, most of it is already incorporated in UK immigration law. So the 7-year policy categorically, I'm saying, is not going to get affected. It will continue. The 20 years category will continue. Less than 20 years category will continue. So all these have already become part of UK law.